Today, we're diving into a high-stakes bond hearing that's anything but ordinary. The defendant, Mr. Barnhart, is facing multiple OWI charges, including one pending in Wayne County. And now the court is questioning whether he can even remain out on bond. The twist? Recent drug tests have come back positive for cocaine, THC, benzodiazepines, and Suboxone just days after he was released. The prosecution argues this shows he's a danger to the community, while the defense claims the timing may allow for doubt. This case isn't just about substances in a system, it's about risk assessment, public safety, and the court weighing prior criminal history against potential for rehabilitation. Who is right? Can a person truly be trusted on bond after repeated offenses? Stick around as we break down the legal arguments, the high drama in the courtroom, and the judge's tough decisions.
Your Honor, Mr. Barnhart is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
The court receipt of the bond violation report from Community Corrections.
I have a report dated September 10th, the progress report, yes.
Yes, Your Honor. And I understand that the defendant was released from jail on September the 2nd, went to Community Corrections to test on September the 3rd. And when he tested on September the 3rd, he tested positive for cocaine, THC, benzodiazepines, and Suboxone. I understand also that.
Now here's where the tension escalates. The court is reviewing the drug test results, and the question is whether these positive results constitute a bond violation. The defense argues the substances could have been consumed before his release, while the prosecution emphasizes his history of OWIs and repeated offenses. Legally speaking, bond violations are serious because they show whether a defendant respects court orders. The judge must consider whether Mr. Barnhart presents a clear and present danger to the public. This is a pivotal moment. If the court rules he violated bond, it could change everything, from bond amounts to potential pretrial incarceration. Would you take the chance of keeping someone like this on bond?
This was his first test, so there is an argument that he may not have been on bond at the time that these substances were consumed. Therefore, it may not be a bond violation. However, I did double check ex-jail, and he was booked on August 31st and released on September the 2nd. So there were 3 days in custody. It's possible that certainly the THC could have been from before. The cocaine, I'm less certain of, with extremely heavy use, maybe 96 hours on cocaine, but no matter what, these are OWIs at least 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument. But
can I have just a second, Your Honor?
Sure.
So, yeah, I just think there's possibilities that he's not used after being arrested. And those,
what?
I mean, cocaine could stay in his system for up to a week if there's heavy use. So the failure.
Let's say, well, I don't know, a week, but let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, I have 2 in front of me and there's another one in Wayne County, then I think that his bond in these cases is inappropriately set. And what I mean by that is that I clearly have these 2 cases. There's the other one in Wayne County. He's got priors and he's still using.
I think I'm fine. I think that's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Yes, sir.
But here's again my problem, counsel. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023 or 25, 23. He's got a pending Wayne County one. He's got prior ones and he's still using. So I don't know that he should be out because at some point luck's going to run out. He's going to get behind the wheel and he's going to take somebody out.
The court is laser focused on public safety, with multiple OWI cases and prior convictions dating back years. The judge stresses that continued drug use while on bond poses a real threat, not just theoretically, but to anyone who might be on the road. The defense argues that if he's not driving, the danger is reduced, but the prosecution paints a picture of repeated risky behavior, emphasizing the pattern of substance abuse. This moment is a classic example of a judge balancing individual rights versus community protection, and it raises an important question. Should prior history outweigh the possibility that this could be a one-time slip?
I don't have a vehicle.
Your Honor, I don't believe he's driving. The test certainly indicates use. Look, drunk driving is absolutely dangerous, but there's no dispute. I think if he's using drugs in his own home, I don't believe that's a danger to the community that rises to the level of him needing to be incarcerated. I think he can remain out if he fails a test. That would be a bond violation at this point because he has been on bond since, I think that would be the 29th, 28th or 29th. So if he fails the test at this point, that would conclusively prove use while on bond. And I think absolutely the court at that point would have undeniable jurisdiction to revoke his bond. I would say that I don't believe the information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me that with all this is legitimately 4 and 5 with another one pending in Wayne County and he's still using, you're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, I wouldn't absolutely not even argue that, no question. I think him failing those tests, and we don't have a pattern or anything like that. We don't know if this is a one-time slip up. We don't know if he's used while he was on bond. I think the court could allow him to test today, and that would solve the problem.
Yeah, may I respond?
Right.
I would wholeheartedly disagree that there's no pattern. I think that the defendant having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his BAC was incredibly high. And I'm going to double check that before I get that search to the court. But if I recall correctly, I think in both cases, his blood alcohol content was above a 0.3.
That's correct, Your Honor.
So we are not, if this isn't a pattern, I don't know what a pattern is. People would request that the court find that the bond is an abuse of discretion and set a higher bond and remand.
I just don't think the circumstances have changed since the bond was set because and I know the court could disagree, but we don't believe there's evidence he's used since the bond was set by the magistrate, at least conclusive evidence. It's up in the air as far as he failed the test.
You keep arguing the use. The argument is, even if I give you that, the argument is I don't know that he should be out. Any use, given his record, and he's out on basically a PR, I think is an abuse of discretion. Now, if you want to argue that with me, certainly I will hear you.
Okay. I think it would not be abuse of discretion because of the length of time that has passed. So, we're already into August 2025. The positive test, we can't really deny it, but what we can say is he's not driving a car. So the extreme danger to the community that comes with intoxicated driving is not present. Obviously, there's some danger to the community in hard drug use, but I believe it's less. I believe it can be managed with restrictions such as continued testing. If he fails again, he's obviously used while on bond. The court could do that. I think the court could order increased testing. You could put him on 3 times a week. I think he was on 1 time a week. I mean, the court could order testing every day if the court felt that necessary. There's a lot of options other than just incarcerating him.
What did you wish these set for?
I'm sorry?
What did you wish these set for? Preliminary examination?
No, he's going to waive.
He's waiving. All right.
The judge makes a decisive move. Mr. Barnhard's bond is changed from personal recognizance to $25,000 cash surety. What does that mean? Essentially, it's a financial guarantee to ensure compliance. He must post the money or remain in custody. Additionally, the defendant waives his preliminary examination, meaning he won't challenge probable cause at this stage. This is a strategic legal decision. The case moves directly to circuit court for full resolution. The takeaway: courts have multiple tools to manage risk and ensure defendants return for hearings, from adjusting bond to using preliminary examination waivers. It's a legal chess game with very real consequences.
At this point, what I will do is his bond is going to be changed. I'm going to set it at $25,000 cash or surety. So you're waiving your right to preliminary examination in these cases?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you will not have that hearing on either one of these matters, and that this will proceed to circuit court for further resolution.
Sir.
People also waive their right.
We waive, Your Honor. I do believe he previously posted $25,000.
Oh, are on both of these?
I think that's what my notes reflect, is that that's what it was set at.
I mean, I thought they were PRs.
Sign the
It
form
might
to
be
waive after
PRs,
this.
maybe $25,000 PRs, but I
There, I have on each of these that they're PR.
Oh, I apologize, Your Honor, my mistake. Thank you.
So people do waive.
We do.
Preliminary examination having been waived, defendants bound over to circuit court on the single count in each case.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea pretrial. Custody pretrial date.
September 24th at 1:30 with good time.
September 24th, 2025, 1:30 before Judge Conlon in each of these matters. Bond, as indicated, is set in each case. It will be changed from a personal recognizance to a $25,000 cash or surety. Defendant is remanded. Yes, you may.
In summary, this hearing demonstrates how judges must navigate complex factors, prior convictions, recent drug tests, and potential danger to the community to make fair but firm decisions. Mr. Barnhard's bond was increased to $25,000 cash surety, and his preliminary examination was waived, sending the case to circuit court. This is a stark reminder that the justice system balances public safety with procedural fairness, and defendants must take court orders seriously. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and subscribe for more gripping courtroom breakdowns. You won't want to miss what happens next.